Freya?
Yes, ready.
Okay.
It was just warming up.
Got it. Thank you. Good morning. It is 8:30 a.m. on the 23rd of July. This is the status conference docket for the New Mexico Oil Conservation Division. I'm the hearing examiner. We do not have technical examiners today. And I'm going to call the cases in the order that was sent out yesterday, with one exception. The first case on our docket is a Goodnight Midstream Permian case, and I'm going to call that along with the Empire cases that are toward the end of our docket. So I apologize, Mr. Rankin, if you were only here for that one case. So let's go to number 2 on our docket. This is 26131. It is joined to 26132, FED Operating LLC. Case numbers, I already said that.
Good morning.
Of appearance, please.
Good morning, Mr. Hearing Examiner. Caitlin Luck appearing for FED.
Thank you.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Permian Resources Operating, and we are just monitoring these two cases.
Thank you.
Good morning, Mr. Examiner. Ernest L. Padilla for Hunt Cimarron Limited Partnership.
Good morning. Did you object?
Yes, we did.
On what basis?
The basis that we had insufficient information from the applicant, we never really got notice of the hearing or much of the paperwork.
Has that been resolved?
No, it hasn't. We're hoping that we can resolve it before any kind of hearing occurs.
Okay, I understand the basis of your objection. Thank you, Mr. Padilla. I think we have Ms. Kessler and one other party. Maybe Ms. Kessler is not here. Who is the other party, Ms. Luck? Is it Miguel Suazo?
No, it's Permian. I believe Ms. Hardy and Ms. McLean are representing them.
I have that entry, but I also have another entry. I wrote down the initials MS.
Oh, I'm sorry. That's Matthias Sayer for
That's
JR
it.
Oil.
There we go. Perfect. Do we have Mr. Sayer? Do you know if Mr. Sayer objected?
It was my understanding from his filing that it was simply an entry of appearance for preserving rights, but I can't speak for him. I'm sorry.
Okay. And what about Ms. Kessler? Because she's not here either. Did she just preserve rights?
That was my understanding as well. I haven't received a formal objection. The only formal objection was from Hunt Cimarron, but again, I can't speak for EOG. I'm sorry.
So far we have one objection from Mr. Padilla, as far as I understand. So how do you want to proceed, Ms. Luck?
We did confer with all the parties before coming to hearing today at the status conference, and we would request the August 25th contested hearing setting if possible.
Okay. All right, Mr. Padilla, we're going to set a contested hearing for August 25th. That gives you plenty of time to resolve your difference, I believe.
And, Mr. Examiner, we also, I think we have the same objection on the following case, 26-132. So
Yes.
they're just.
Yes, Mr. Padilla, I called both cases and I noted your objection in both cases.
Thank you.
Yes, thank you. All right, I will issue a pre-hearing order for August 25th. Sounds like this can be resolved, though.
Yes, thank you.
All right, anything else, Ms. Luck?
No, thank you for your time.
We're off the record in these two cases. Let's move on to Matador Production Company. I think we have a few cases here. Let me call all of them. 26147, 148, 149, and 150.
Good morning, Mr. Hearing Examiner Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of the applicant in these 4 cases.
Thank you, Mr. Rankin.
And good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of BTA Oil Producers, LLC.
And are you preserving or did you object?
We did object to these cases.
Why?
Because BTA is trying to work with Matador on a potential agreement and owns a significant interest. And if necessary, they'll propose competing wells, but they're hoping that this gets resolved.
Understood. We have 2 more entries of appearance. Mr. Larson? Freya, did Mr. Larson get notice of today's hearing?
I don't know if he's on the listserv, but the link and notice of hearings are posted on our website.
Mr. Rankin, about Mr. Larson?
Well, I used to litigate against him, and I know he knows about the division of procedures.
He does.
But, so I don't know if he's in or not, but I do know, I believe that the parties are talking, and I can maybe cut to the chase a little bit, if that's okay.
One more moment. We also have another entry of appearance too. Do you know who JK is?
Probably Jordan Kessler.
That's probably right. Okay.
Yeah.
Is she objecting or just monitoring?
I believe in this situation, she's just monitoring. Yeah. Otherwise, we would be.
So yes, cut to the chase. Thanks.
Yeah. So the chase is that the parties are in discussions, and we have agreed that we'd like to have a second status conference at the end of August. I think we're hopeful that we can reach an agreement with BTA and the other parties so that we can move forward without having to go to a contested hearing.
Okay. So this case was filed on May 4. Another status conference would be the final status conference then. So, Mr. Rankin, if you're not able to resolve your differences with the other two parties, please be prepared to choose a date for a hearing.
We will be prepared, and we appreciate the heads up. I believe, I'm hopeful that the parties will be able to reach an agreement.
Oh, sure, of course. And Ms. Hardy, the same to you. If you're looking, please advise your client that if they're going to file competing applications, they need to do it with the idea that we'll hold a hearing probably in September, because these cases were filed in May, and I don't want them to get too old.
Understood.
Okay. All right. I don't understand why Mr. Larson did not attend today's hearing. Freya, would you send Mr. Larson an email letting him know that we heard these cases today and he's really not representing his client properly without attending these hearings?
Yes, I will send a message.
Because I want to know why he's objecting, and it doesn't. Still have no idea. But thank you very much. Okay, we're off the record in these cases. Final step. We're going to move on to Permian Resource Operating. This is one case, 26151.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Permian Resources Operating.
Thank you. I know we have Ms. Kessler, and she's not here. What about Ms. Shaheen? Do we have you? I know Sharon Shaheen is definitely on our listserv. Any idea why Ms. Shaheen wouldn't be here today?
No, it was my understanding she was going to be here. Maybe she wasn't aware of the time change in the docket, but I will send her a message. I can send her a text message.
All right, I'll recall this case because she's objecting, is she not?
She is.
Ms. Kessler is probably not objecting?
Correct.
All right. Yeah, I'd like to hear from Ms. Shaheen. I know this case was filed May 4, so it's not that old, but it is over 2 months old at this point. And yeah, I'm going to recall this case. So we're in recess on this case. I'm going to move on to Americo Energy Resources 26202.
Good morning, Mr. Hearing Examiner. Caitlin Locke appearing for Americo.
Morning. I have Olivia Standish.
That's correct. Yes, she's the attorney for Pecos Valley, which is the Water Conservancy District involved in this case.
Ah, okay.
Good morning, Mr. Hearing Examiner. I'm attending online.
I
Olivia
see you.
Standish. Okay.
I see you. Welcome, Ms. Standish. You objected
you.
to this case going forward?
Yes, sir.
Okay. On what basis?
I represent the Pecos Valley Artesian Conservancy District. They are objecting on the basis of protection of fresh water in that particular location.
Okay. And
We have had a conversation with the applicant, and so we are in the process of potentially working through those issues.
Okay, Ms. Luck, are you satisfied with the basis of standing for this objection?
Yes, Mr. Hearing Examiner, we did have a pre-application filing meeting with Mr. Getz and his injection team. At that point in time, we met with Pecos Valley involved because they are the state engineer's designee basically in this case to preserve and protect the groundwater in the area. And just given the fact that this is a special artesian water district, they do have, and they are afforded special rights with respect to standing.
Sure.
So at this point in time, we have met with, and by we, I mean, my client Americo has met with the Pecos Valley team on Tuesday to try to work through some of their concerns. We've listened and we're discussing a potential permit condition stipulation, which I do owe Ms. Standish at this point in time, but the parties are continuing to work through potential permit conditions and provide information, and we would like to request a contested hearing in August.
Okay. Ms. Standish, did you attend this Tuesday meeting?
Yes, I did.
Okay, good. And what happened at the Tuesday meeting?
What Ms. Luck has represented is an accurate discussion or an accurate reflection of what we've discussed. We are in the process of exchanging information between our teams to see if this is something that we can stipulate. However, we do understand that everyone would like to move this forward as quickly as possible. And so we had discussed potentially an August 25th hearing date.
Okay. Does that work for you?
Yes, Mr. Hearing Examiner, I understand that the opponent is not available on the other date that's available August 18th, so August 25th works for us. Thank you.
Okay. All right, we'll set this for a contested hearing on August 25th, but it sounds like with the permit condition, that may not be necessary.
Yes, that's correct. Thank you.
All right, you're welcome. Thank you, Ms. Standish.
Thank you.
All right, we're off the record in that case. Let's go on to, and Freya, will you let me know when Ms. Shaheen joins us?
Yes.
Did you hear back from Ms. Shaheen?
I did not hear back from her. So I'm not, she was planning to be here, so.
Especially for Empire, right?
Yes, I'm not sure what's going on.
Right.
Hopefully she's okay.
Yeah, of course. Hopefully, yeah. Okay. Well, if you hear back, let me know, please.
I will, thank you.
But you're not relying on her for the Empire case?
Correct.
Okay, all right. Let's move on to number 10 on our docket. This is 26233. It is Permian Resource, and it is joined with case 26234. Entries, please.
Dana Hardy on behalf of Permian Resources.
Perfect.
Good morning, Mr. Hearing Examiner Adam Rankin, Santa Fe of Holland Hart, appearing on behalf of Matador and its associate companies in these cases.
Is Ms. Vance also entered?
She is on behalf of the law firm. We've entered it as a law firm on their behalf. Yeah.
Okay, but we don't need her here today.
No, we do not.
Okay, very good. And did you object?
We did.
You did. Why?
Because we have competing counter proposals and a competing set of cases, which I can give you the numbers for.
Yes, please.
The competing cases are Matador's Bill Wilshusen FedCom wells, and they're case number 26332, 26333, and 26335.
Thank you. And they directly compete with these two cases?
Yeah, forgive me for not having the acreage in my mind. There may be some partial overlap. I'm not sure if they completely overlap. I think it's more of a partial overlap. In this
Oh,
case.
I see.
Yeah.
Okay, all right. And Ms. Hardy, you were aware of those?
Yes.
You are, okay.
And I think we had other appearances.
We do.
A couple of
I'm
other,
just
okay.
asking if
Yes,
you have,
yes.
if you were
thank
aware of those.
We did
competing-
object to those yesterday.
Oh, I didn't
Those
know.
applications, yes.
Okay, very good. So we have two other, go right ahead, Mr. Goodwin.
Hi there. Good morning, Mr. Hearing Examiner. Jeff
Morning.
Goodwin with Module Sperling on behalf of Avant Operating 2, and we're just monitoring these cases.
Very good, thank you. Ms. Luck?
Good morning, Mr. Hearing Examiner. Caitlin Luck, appearing for WR non-op in these cases. No objection, just preserving rights. Thank you.
Okay, thank you. Monitoring. All right, so we have competing cases for compulsory pooling. Ms. Hardy?
Mr. Examiner, so the competing cases were filed for the August docket since we objected yesterday. Now they're set for a status conference on August 20th. And we had consulted with counsel for Matador and have agreed that these two cases as well should be set for the status conference on August 20th.
Okay. And that's fine. When we have the status conference in August, are you going to know whether you want a contested hearing or not?
I would expect so. I hope so.
All right, then I'll mark. I know these cases are new for you, Mr. Rankin, but I'll mark it as a final status conference because ultimately that's why you filed them, to either go to a contested hearing or resolve the issues, right?
Correct. I mean, I do believe that there's a likely potential for these to be resolved. There are so many things going on in the world and everybody's business. So I would maybe ask just for potential some flexibility if they aren't quite at that point yet, but appreciate the consideration. Understand. I will say that they're working to try to get this resolved, but just in the event that it isn't, some flexibility to potentially have an additional month or so to get it finalized. Appreciate
that makes sense. I mean, these Ms. Hardy's cases were filed just last month, so
yeah,
that makes sense to me as well. I'm still going to mark it final, but you can talk me out of it. Sounds like you're already starting to. All right. Okay, so I had called both cases, right, Ms. Hardy? I called both cases? All right, sounds good. All right, we're off the record in those two, in those two cases. I'm going to recall Permian Resource Operating case now that Ms. Shaheen is here. Ms. Shaheen, we called case 26151 in which you entered an appearance.
That's, yes, Sharon Shaheen on behalf of Flat Creek Energy.
Okay. And your status in the case?
Yes, I understand. I spoke with Ms. Hardy yesterday or the day before, and I understand that Permian wants to go to a contested hearing on August 15th. Is that correct?
I don't know. We stopped because you hadn't entered your appearance, so.
Okay.
Yes.
But I'm still asking Ms. Shaheen. So when I call the case, Ms. Shaheen, I'm asking for not just an entry of appearance, but I'm asking for, did you object or did you not? And if you did object, why?
Yes, we did object, and there are a number of reasons why. First of all, Flat Creek believes that these should be developed as 2-mile wells. With 2-mile wells will be enhanced economics. They have begun discussions with Permian in this regard, and we believe that more time is necessary to get this resolved. I do have some other notes here if I could.
Sure, take your time.
If you could just give me a minute. And my apologies for being late. I didn't realize we were starting at 8:30.
From now on, we start at 8:30.
Good to know. Maybe I can do this from memory. If this can't be resolved, Flat Creek plans to propose competing development with 2-mile wells. We believe it should be, we could get well proposals out by August 8th, which would put it on the October docket. And also, I do have a conflict, and I don't know whether I'll be able to get a waiver. We may need to get additional counsel to step in.
For Flat Creek?
For Flat Creek, yes.
Okay, all right. This case was filed by Ms. Hardy on May 4. So October will be 6 months at that point, half a year. So I'd want to have a contested hearing in October. So I'm letting you know so that you can plan appropriately to file your competing application in time for an October contested hearing. Ms. Hardy, ultimately, this is your case. How do you want to proceed?
So, Mr. Examiner, in this case, Flat Creek is not being pooled, and they haven't filed competing applications. Permian Resources, is developing adjacent acreage and wants to develop all of it at the same time to avoid parent-child effects and those types of impacts. And the adjacent acreage is subject to a lease expiration. Right. And so Permian Resources would like to proceed to a contested hearing in August and would prefer the August 18th date. I think Flat Creek has had time to propose competing wells if they were going to do that, and they haven't done it.
Ms. Shaheen, you're not being pooled?
I was not aware of that. I believe we do have an interest in a 40-acre tract in the planned 1.5 mile wells. They did not receive certified mail notice. I don't know about whether Permian seeks to pool Flat Creek, but we assumed, since we haven't voluntarily agreed to participate, and we do own an interest in a 40-acre tract, that we would be pooled. With respect to the offset development, those wells, I understand, have already been drilled and can be turned on and produced at any time. It's Permian's, I guess it's Permian's choice as to when they turn those wells on. But I don't believe that the lease expiration requires us to go to hearing sooner when proposed 2 mile wells would be better than the proposed 1.5 mile wells.
Ms. Hardy, you're sure about if she didn't get notice, then maybe that's why, because there was no interest, but what can you say?
There may be some, I think there are other entities owned by Flat Creek, and it's possible that one of those is included, but Flat Creek itself, which has entered the appearance and objected, is not the owner of the interest.
I see.
It's my understanding.
Well, what we can do is, so Ms. Shaheen, what we can do is we can set a contested hearing, and then if something changes along the way, we can continue it to another date with good reason to do so.
If I may, I believe perhaps Ms. Hardy is referring to FE Permian, which is a Flat Creek affiliate.
Okay.
And perhaps I should have entered an appearance on behalf of FE Permian, and I will do that now.
Okay. Fine.
So that it's clear. It's possible that it's not Flat Creek itself that owns the interest, but it's affiliate FE Permian.
All right, so you're entering an appearance for FE Permian, okay. All right, I don't know how that changes what Ms. Hardy is requesting, though.
Well, if I understand correctly, Ms. Hardy is requesting that it go to a contested hearing on August 15th because of this purported lease expiration. And as I pointed out, the lease expiration is really not affected by this, this proposed development.
I think Ms. Hardy is asking for an August 15th contested hearing because she asserts that Flat Creek or FE Permian has had time to consider their proposal and could propose their own development and hasn't done so.
If I understand correctly from Flat Creek, FE Permian, they never received certified mail. Even FE Permian never received a certified mail of notice of the May 4th application.
I see.
And so they only learned of it through some other secondary source. And so they technically, if they didn't receive notice, they haven't had much time.
I see.
Right?
Sure. So let's do this. Well, I'm gonna recess this case again. I'm gonna allow you both to email your clients and find out what is the truth here, because I have no idea what the facts are. It sounds like there's some guessing going on, and I'm not willing to continue on that basis. So Ms. Hardy, please contact your client. Ms. Shaheen, please do the same. Find out who is the client, first of all. Is it FE Permian or is it Flat Creek? And if so, did they receive notice? Did they not receive notice? I'd like to know. I'll recall this case at the end.
Sure. Thank you.
Thank you.
Thank you.
Freya, don't let me forget to recall this case, because after the Empire good night, who knows if my brain will be fried or not. Everyone else's is, mine too. All right, so let's see, Permian Resources, we've done that. Okay, it looks like we're going on to NSP Resources. This is case 26243, number 12 on our docket. Entry of appearance, please. Machine, I think it's your case.
Yes, Sharon Shaheen on behalf.
Will you turn on your microphone?
Sharon Shaheen on behalf of NSP Permian.
Thank you, Machine. Mr. DeBrine? Oh, no, Mr. Goodwin. Very
Hi.
good.
Good morning, Mr. Hearing Examiner. Jeff Goodwin with Module Sperling on behalf of Coterra Energy Operating, and we've objected to this case.
You have. And do you know why you've objected?
Coterra sent out counter proposals, which have just become ripe to file our applications, and we will do so in time for the, I think it's September 6th docket.
Okay. I understand.
The Coterra Intrepid 2-3 competing application overlaps exactly with the Sunhawk development. I do understand that Coterra and North Star or NSP Resources are in discussions, and they're still progressing.
Okay.
So while we're hopeful that those negotiations will be fruitful, we also want to set a contested hearing date.
Okay, that's helpful. Thank you, Mr. Goodwin. Ms. Shaheen?
Yes, NS Permian would prefer to set this for another status conference. If their applications are ripe on September 3rd, it seems like September 17th would be the appropriate status conference.
We would hold a hearing in September or October at the latest. So if you want another status conference, you can continue your cases to the August status conference docket, and then we'll set it. But do we have, Freya, let's give out some dates for September and October now, so Ms. Shaheen and Mr. Goodwin can consider those dates.
Right now, we only have one special docket in September. That's September 15.
I'm sorry, you said what?
September 15th.
September 15, yes.
And then October 20th and 27th.
All right. So we have these dates to offer you, Ms. Shaheen and Mr. Goodwin, September 15, October 20, and October 27. So please consider those when we return in August.
Thank you.
All right, thank you. Mr. Goodwin, anything further?
Thank you. No, that should be good. Thank you.
All right, Ms. Shaheen, anything further?
Not from North Star.
Wonderful. Oh, is that what that NSP is, North Star?
It's another one of those where they're affiliates and they're sometimes interchangeable.
Very good. I understand. Thank you. Appreciate it. Now, it looks like we have another NSP case, or North Star case, number 13 on the docket, 26244.
Sharon Shaheen on behalf of North Star.
Thank you.
Jeff Goodwin with Module Sperling on behalf of Coterra Energy Operating. Again, we've objected to this case, and our position is the same. We've sent out counter proposals, and we plan to file our applications in time for, was it September 6th docket? Or was that correct?
Yeah.
Okay.
Yes.
And yes, our Coterra Intrepid 234 competing application overlaps with the Osprey 2-3, and then covers some additional acreage as well. So again, we know that there are discussions happening, but we would like to set a contested hearing date.
Perfect. So the same instructions in this case, Ms. Shaheen. Please continue this case. Should we join these cases or not? Your two cases.
Right, that's a good question, and I don't know.
Okay. Then, please, Ms. Shaheen, please continue these two cases, 26243 and 44, for a final status conference in August. What's the date of the status conference docket in August?
It's the 20th.
August 20? Thank you.
Yes.
So August 20, Mr. Goodwin, I know your cases won't, well, maybe they will be. Maybe we can talk about your cases with a number by then and possibly join them to these cases and issue a pre-hearing order for either September 15, October 20, or October 27.
And if I may just
Yes, of course.
request that Mr. Goodwin provide me with copies of the applications when they're filed.
Mr. Goodwin?
Of course, we will do that.
Thank you.
Wonderful. And Ms. Shaheen, please speak to your client about those dates so that they can choose one of those dates, their witnesses be available?
Will do.
All right.
Thank you.
All right, if there's nothing further, we're off the record in those cases. Let's move to Longfellow Energy 26252.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak, appearing on behalf of the applicant Longfellow Energy.
Good morning, Mr. Suazo.
Good morning.
Mr. Rankin?
Good morning, Mr. Hearing Examiner. Holland and Hart appearing on behalf of Adam Rank with Holland and Hart appearing on behalf of Spur Energy Partners in this case.
Thank you. And you've objected, Mr. Rankin?
We have.
I'm not surprised.
Yeah.
And your basis of your objection?
Spur is preparing counter proposals and will be circulating those to all parties here. Probably, I think I don't know exact time frame, sometime in the next week or 10 days is what they're trying to get it out as quickly as they can so that they can file. It won't be ripe for the September docket, but it would be ripe for the October docket.
Thank you. The acreage overlaps?
It does. Yeah.
Okay. Mr. Suazo?
Well, that's the first I've heard that they intend to file competing proposals, being that the case, assuming that the calendaring works out. Obviously, we want to set this for a contested hearing as soon as possible, and if October is the soonest that we can do it, I guess that's fine unless there's a way to get it earlier.
It might be doable in September, especially if Mr. Rankin files them in the next few weeks. I don't see why we couldn't have it on the September 15th docket. But why don't we do this, Mr. Rankin? How about you continue this case to the August 20th status conference docket, and then we can set a hearing at that time?
We will do.
All right. I'm sorry. Why am I saying Mr. Rankin? Mr. Suazo, I meant you.
Sure, we can do that.
Would you please continue this case? I got confused. I apologize. To the August 20th status conference docket?
Yes, Mr. Examiner, we'll get that done.
And then at that time, we can evaluate the counter proposal, and we can also see if your witnesses are available September 15, along with Mr. Rankin's. If not, then we'll have the August 20th or 27th.
Okay.
All right. Anything further, Mrs. Suazo?
No, Mr. Examiner, thank you.
Mr. Rankin?
Nothing further.
All right, thank you. Let's move on to another NSP resource case, 26287, number 15 on the docket.
Mr. Examiner, good morning. Jacob Everhart with Beatty and Wozniak, New Mexico, appearing on behalf of North Star Resources.
Good morning, Mr. Everhart.
Good morning.
Good morning, Mr. Examiner. Adam Rank with the Santa Fe Office of Holland and Hart, appearing on behalf of Newborn Oil, Permian Resources Operating, MRC Permian, and MRC Delaware Resources.
And your status?
In these cases, I believe, forgive me, these were all just new. I think we're objecting on behalf of Permian and MRC Delaware.
Okay.
I think Mewburn is in there as well.
Is it Mewburn objecting to? I apologize if I missed the
Yep.
objection. Okay, yep.
Thank you, Mr. Everhart. Why are you objecting? Do you know?
These just all came up. I'm still trying to figure it all out, so I apologize for not being
All right.
totally apprised. But yeah, obviously a lot of parties involved, a lot of issues. So I'm going to request a status conference at the end of August so I can figure out exactly where everybody is. And I think everybody probably would appreciate that because we're still trying to figure out what the positions are going to be. Because there were a number of wells filed by applications filed with NSP, and working to figure them all out right now.
All right. Thank you, Mr. Rankin. Mr. Everhart, it's your case. How do you want to proceed?
Yeah, so I think ideally we would like to move towards the most recent or the fastest available contested hearing, preferably in August or September 15th. It sounds like the August date's getting pretty full. North Star's had some discussions with Permian, but those discussions kind of leave us with low confidence that it's going to result in a like-for-like trade. We have some meetings scheduled with Permian next week, but considering some of the investment progress that North Star has invested in the Wild Goose unit to date, we want to charge ahead as an overwhelming working interest owner, about 50% with 8 committed and another 5% expected to be committed in the next week or so. We have plans for Sputter Rig in November, so we like to move quickly on this one.
I understand, Mr. Everhart. It sounds to me, this case was just filed in June. I do use the filing date as a barometer of
Yes,
how
sir.
quickly I'm going to set this. It sounds like Mr. Rankin's clients, he needs to really figure out where his clients are. What I'll do is I'm going to ask you to continue your case to the August 20 status conference docket. I'll mark it as a final status conference so that we do get this set for either a September or October contested hearing. And that way you have time to talk to your client about September 15, October 20, or October 27. All of those dates are before that November date you just mentioned. I think that's the best I can do.
Okay, we'll work with that.
Mr. Hearing Examiner,
Yes.
just one moment, because I think there were some changes in the well name. So what's listed here is Wild Goose, and I think maybe the well name is actually the Spruce Goose, or was it changed to Wild Goose? Part of my confusion is because of the name. There may be a name change due to amended application. And I think in this case, in this situation, I believe that Permian does have a meeting set up with North Star on the 28th of this month.
Okay.
And so they've asked me, based on the status, if September 17th, the status conference on the September docket would work. Now that's pushing it out farther, but again, this was just filed in June, and there's working to get potentially have discussions at the end of this month. And so, they've asked me to ask for a September 17th status conference for this particular case.
So, Mr. Everhart, the applicant, counsel for applicant, I feel like I'm already not doing what he's asking me to do based on your position with your clients, but I feel like I don't feel comfortable pushing this to September status conference. Let's find out what's going on in August. If there's some new information, or if Mr. Everhart backs off of his request for a contested hearing sooner, then I'm more comfortable with that. Or if you're gonna file competing applications, possibly, I don't know what's gonna happen here, but I don't feel comfortable going that far out at this time.
Understood.
All right. Yeah, I'm just trying to accommodate both parties here at the same time. So, Mr. Everhart, about this Wild Goose, Spruce Goose name, do you know anything about this?
Yeah, it was originally filed as Spruce Goose, but there's an existing unit called a Spruce Goose, and so we changed it to Wild.
So it is accurate then?
Yes, sir.
Mr. Rankin?
I think it was originally filed and noticed as Spruce Goose, and so I think there was an amendment. I'm not sure if so I figured that out when I went to the case file, because there was a supplemental filing. It just got me confused.
Okay. Well, anyway, I think that's been cleared up now, so I think we're good. Anything further, Mr. Everhart?
No, sir.
All right. Thank you. We're off the record in that case. Let's move on to Spur Energy Partners. This is a very familiar case to me, and I know it will be to Mr. Suazo as well. Case 26288. Entries, please.
Good morning, Mr. Hearing Examiner. Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of the applicant Spur Energy Partners.
Thank you.
Good morning, Mr. Examiner. Miguel Suazo with Beatty & Wozniak, appearing today on behalf of Longfellow Energy.
Thank you. Let me just give let me just give a little bit of background to this case. It's a bit of an interesting one. Several months ago, Mr. Rankin filed an emergency motion for a stay. It was denied based on the evidence provided. There was a motion for reconsideration. That was also denied. Then there was a application filed on June 9, basically asking for basically raising the same issues in the motion and the motions. And that's what's before us today. Now, there was a motion to dismiss that application filed by Mr. Suazo based on my rulings, and I issued a detailed order with findings of fact and conclusions of law substantiating my decision to deny the motion to dismiss. So we're going to a hearing on this case, and I would like that hearing to be sooner than later. Mr. Rankin, when can you be prepared for a contested hearing on this case?
I'm unavailable for August, but I conferred with the client. Spur can be available for September 15th, which I think is the earliest special docket for a contested hearing.
Okay, I thought you just said that you were available for August.
Unavailable.
Unavailable. I heard the
Unavailable.
word available.
Yeah.
Okay. Okay, Mr. Suazo?
Well, obviously, we'd like to get this resolved sooner rather than later. I don't know if it's possible for Mr. Rankin to have a colleague stand in his stead, but I think the sooner we can get this resolved, that would please my client.
Right. Mr. Rankin, you're unavailable for the entire month of August?
Substantially, yes. Yeah.
Your application raises some clouds over this development, and the development is already in progress. We want to hear the evidence. The division really wants to hear the evidence on this quote unquote deviation. As you characterize it, when are you available in August?
I'm involved in an arbitration. It's going in Houston. And then I'm taking my son to college at the end of the month. And so basically the last 2/3 of the month are no good for me. Okay. And based on my Spurs availability, I don't know that I understand from them that they were available in September, but not in August, based on my discussions with them. So I don't know if the witnesses are available for early August or not. I don't think that they would be. And so that's why we had picked September. We may be able to do an earlier date in September, but I think based on conflicting, impeding already, my schedule, I don't know that I can't do September. I can't do August, yeah.
Freya, if we were going to set this as early in September as possible, can we just choose? Is there some reason we can't do an earlier date in September?
We could do September 1st.
Okay.
Or September 9th.
Okay, let's say September 1st. Mr. Rankin, can you, it's your burden. You have the burden of persuasion, okay? So obviously your witnesses have to be available, but would you check with your client for September 1st?
I'm checking both September 1st and September 9th.
Perfect, thank you.
Right
Mr. Suazo, if I could get this to a hearing any sooner, I would. It is Mr. Rankin's case. I realize that you have the cloud over your development, but it is Mr. Rankin's case, and he has the burden. So in the meantime, would you check with your witnesses, Mr. Suazo, for September 1st and 9th?
Yes, I can commit to September 1st on behalf of the client. The problem with September 9th is I'm actually speaking at a renewable conference in Salt Lake City, so that is out for me.
Okay, all right, understood. Why don't we go in recess on this case? And when you hear back, Mr. Rankin, will you alert me?
I will.
All right, Mr. Suazo, we're going to come back to this case. I'm going to recall it after we hear from Mr. Rankin, okay?
Okay, thank you.
All right, thank you, sir. Okay, I'm going to move on. That was number 16 on our docket. I'm going to move on to the Empire Goodnight cases. Now, I say Empire and Goodnight. Goodnight had the first case on our docket, 24491. And that was an extension, an amendment extension to commence injection operations case. But I thought we should hear it with the Empire new cases, the 13 new cases seeking to revoke injection authority from various operators, both within the EMSU and outside the EMSU. So I'm going to call all the cases together. These are cases 24491, 26255, 64, 67, 69, 73, 75, 77, 78, 79, 80, 81, 84, and it looks like 26274. I don't know why the numbers aren't in order, but there they are. Entries of appearance, please.
Mr. Examiner, Dana Hardy on behalf of Empire, and also appearing for Empire is Ms. Sharon Shaheen.
And Ms. Hardy, are you also entering the appearance in 24491 as well?
Yes.
Very good, thank you.
Good morning, Mr. Examiner. Adam Rankin with the Santa Fe Office of Holland Hart, appearing in all of those cases on behalf of Goodnight Midstream Permian, as well in every case but 24491 for Parker Energy Services.
Well, hold on, Mr.
Yeah.
Hold on, Mr. Beck, just one moment. I don't understand. What were you saying?
So, entering appearance
Yes.
in all the cases
Yes.
for Goodnight Midstream Permian. We have also entered an appearance
That's what you meant, okay.
for, I may have bungled my language.
I understand now, for another party.
For another party, Parker Energy Services is appearing in every other case but for the extension case for the Rocket case. Okay.
And before I go to Mr. Beck,
Yeah.
Parker,
Parker,
and what do they do?
they dispose of
Oh,
water.
they do, okay.
They're one of the wells that's being targeted by Empire. Yeah.
They are.
Yep.
Perfect. I didn't know that, and I appreciate the information. Mr. Beck?
Morning, Mr. Hearing Examiner Matt Beck, Piper, Hanson, Mullins, and Baker on behalf of Rice Operating Company, Permian Line Service LLC. We have not entered an appearance in the 24491 case, as I don't know what that is, and so we'll see if.
But you have entered an appearance in all 13 other cases?
Yes, Mr. Hearing Examiner.
Very good. Are there any other entries of appearance?
Yes, good morning, Mr. Examiner. Miguel Suazo with Bading Wozniak, appearing on behalf of Pilot Water Solutions, SWD.
Thank you, Mrs. Suazo. I thought Pilot was in Texas. Are they also in New Mexico?
They're also in New Mexico.
All right, thank you. Okay, let's deal with 24491 first, Mr. Rankin, because I think it's a little bit of a different issue. However, I see them all intertwined, so I have questions that I'm going to ask the parties. I've come up with a list of questions to help me determine Ms. Shaheen's. Well, let's first say that Ms. Shaheen filed, I'm sure everyone has this, a motion for referral to the commission. You've received it, right?
Yes, and I wasn't sure, did it include 24491?
No,
the extension
it did
case?
not.
Okay, I didn't think so. Yeah.
Now, I lumped that together because really it's all part of the same fight. However, no, she did not.
Okay.
Mr. Beck, you have that motion?
Yes.
Okay. And Mr. Suazo, you have that motion?
I don't think we've entered into 24491, but like Mr. Beck, we've entered into the other 13 cases.
And the motion for referral was for the 13 cases.
Okay, sorry, what was your question?
The question is, I see that all the parties have opposed the motion for referral.
Correct.
Okay, and everyone is, I'm assuming everyone's going to respond to the motion in opposition. So I'm going to give a 1-week deadline. I know you've had it already for several days, but I'm going to set it for a week from today is the deadline.
Mr. Hearing Examiner,
Mr.
we got the motion to refer yesterday afternoon.
Okay.
And Rice and Permian are intending to file a motion to dismiss the applications. I think other parties are. And so I sent around this morning after getting the motion to refer a proposed scheduling order for briefing on both of the motions. And I have it. I don't think anyone's other than me really had a chance to review it, but I have it on my computer and I can share it on Teams.
Please, go ahead. So let me understand something, Mr. Beck, before you continue. You're going to respond to the motion to refer with a motion to dismiss?
No, so Mr. Hearing Examiner, I just put up on the screen this proposed order. Let me get through the 2 pages of case numbers. So the scheduling order contemplates that this came before you today, that on July 22nd, which is yesterday, Empire filed a motion to refer cases that at least Rice Operating and Permian Line Service intend to file a motion to dismiss, and others might. And so what it does is it provides a proposed response deadline of August 10th to the motion to refer, August 25th for a reply, and it proposes August 10th, that same deadline, for any motions to dismiss, August 25th for responses, page limits of 15 for motions and responses and 10 for replies. And then I think that will, my thinking behind this was rather than us debating timing of filing motions to dismiss or other motions, given the motion to refer, that, and I know that all the parties want to expeditiously deal with this, as probably the commission and the division do, laying out something like this to give us some guidance, knowing that briefing on all of these would be done by September 9th could help us expedite these sort of preliminary processes.
You would have to come up with a really good argument on why I would allow replies, first of all. So I'm not considering the reply schedule here. We have a motion to refer that was filed yesterday based on what you have here. And I don't know if the other parties have seen this document yet?
I don't expect that they have.
Okay.
I think this is the first everyone's seeing it. As I said, I just thought this morning that we would have something to talk about and could have it entered today. That was my thinking.
I see. Okay. The motion to refer is on the table first. You're contemplating responses to the motion to refer on what date?
It would be August 10th, which is approximately 18 days. I was just thinking that because I had August 10th as a deadline in my mind for filing motions to dismiss, given the motion, so.
I'll come to you, Ms. Hardy, in just a minute. And I know Mr. Rankin seems to want more time, not less time, for the motion practice, right, Mr. Rankin? Isn't that why you slapped your head a moment ago when I said a week?
Yeah, well, that was one thing, but I also wanted to kind of make a suggestion, another suggestion.
Sure.
Not to make it more complicated. But, you know, under the division's rules, whether a case is to be heard by the commission in the first instance is a decision that's solely within discretion of the division director.
That's correct.
And my thought here is, just given the burden on all the parties and yourself, Mr. Hearing Examiner, that perhaps we might seek guidance from the division director whether he would want to hear briefing on a motion to refer in the first instance, and if he's even contemplating whether the commission should hear this, you know, in the first instance, then we would brief it. And if he's disinclined to even bring it up to the commission and would want the division to hear it in the first case, then we wouldn't brief it. So my thought is to first just get direction from the division director. Does he want the parties to brief this? Does he want to hear argument on why the commission should consider taking this in the first instance? And if he does want to hear that, then maybe we would then brief. That was my initial suggestion.
Okay.
Before we got into a briefing schedule.
I understand. So let me just get the schedule down first from Mr. Beck so we all have something to talk about. And then I'll go to you, Ms. Hardy, because they are your cases, except for the 24491 extension case, which I did remove the stay, obviously. But based on some questions I have for the parties, all the cases are affected by the answers to these questions. Mr. Beck, you're suggesting 17 days to file a response to the motion to refer. You're also proposing August 10 as a deadline for any motions to dismiss. Is that the idea?
Yes, Mr. Hearing Examiner.
All right. Why do you feel you need 17 days to respond to the motion to refer?
I think it was more geared towards briefing on the motion to dismiss. And what I expect is that the two will overlap.
Okay.
And so rather than doubling the work of the hearing examiner, the division director, and the parties, it seemed to me that putting those two in tandem made a lot of sense.
Okay. And so if, in fact, we went with that deadline, then ultimately I would impose a 7-day deadline for responses to motion to dismiss would be August 17. And that would be the end of the briefing for me. Ms. Hardy?
Mr. Examiner, it doesn't seem to me that quite that much time should be necessary for responses to the motion to refer or the motion to dismiss. At least I know Mr. Rankin was contemplating a motion to dismiss. These applications were filed. I think they have plenty of time to do that. I don't oppose a little bit more time. I mean, I would propose if we filed the motion yesterday that responses and motions to dismiss would be due by August 5th. That's 2 weeks. And then we could submit our response within a week.
Mr. Beck, or Mr. Rankin, whoever wants to answer this, on what grounds would you seek dismissal of the applications?
At least for Rice and Permian, what I've thought about is the lack of standing, the lack of an injury, given the previous orders by the commission. I also will point out, one of the things that is referred to in the motion to refer, not to double up on that word, is that the commission has said that it will hear both the motion to lift the stay and the motion to dismiss other related applications that are related to this. And we heard from the commission yesterday that hearing is likely to be set in September. So I don't expect a lot of the same issues in these motions will be the same for those. And so I don't expect that if we do take until August 25th, weeks in advance of that hearing, I don't expect it will cause any delay for any of the parties here.
I want to explore what you said a little bit further. You said you felt like grounds for motion to dismiss would be based on lack of standing, Empire's lack of standing?
Yeah, yes, you would have to have an injury in fact as part of the standing. I haven't briefed it, obviously, because I was thinking we would do so in the future, but that's my recollection from previous cases. And we've got a commission order that says that there's no current impairment to Empire's production, even in the EMSU.
I did some research on this morning to be prepared for today's status conference. I went back over the two orders that the commission issued, the September and the December orders, and in my reading of the two orders, I came away with the following basic findings from the commission. Number one, that the ROZ existence in the Grayburg San Andreas was proven by substantial evidence, core analysis at EMSU 679 and RR Bill number 4, and that Goodnight's own witnesses agreed oil is there. I'm not asking for debate on this, I'm just telling you what I found. ROZ recoverability, physical and economic. I believe there was insufficient evidence either way, not disproven, just unproven. Current impairment of Empire's correlative rights, not shown. EMSU still produces approximately 800 barrels of oil from the Grayburg, no well-specific production data tying that to Goodnight's disposal. Future impairment, waste potential. Empire did carry this. Goodnight could not establish a continuous containment barrier, which is why the commission left the door open rather than denying Empire outright. So when it comes to standing, I think that's a high hurdle for you to show. But fine. File your motion. I have some questions I want to ask at this point, based on my reading of the orders. I have some questions. So, and some of them are going to be directed to you, Ms. Hardy, and some to Mr. Rankin. I don't know if I have questions directly to you, Mr. Beck, maybe.
I'm happy to play the second chair to Mr. Rankin.
All right. Okay. Ms. Hardy, has Empire commenced the CO2 EOR pilot project authorized by the Commission's orders?
Empire has submitted the Form C-101 to the division for approval that would allow them to commence a test of whether the ROS is recoverable. And the division just recently, within the last couple of days, denied that because they had concerns about other matters involving inactive wells. And so Empire is resolving those other matters, but they are prepared and intend to commence the CO2 project.
Okay. All right.
Mr. Hearing Officer, may I please address that question?
Okay, I didn't know you were going to have a response to that one. Hold on one second. Ms. Hardy, is any recoverability data available yet?
No, not yet. It takes time to commence the project and then do the test.
Mr. Rankin?
I wanted to correct the premise of the question.
Go ahead.
Because you asked whether they had commenced the CO2 project that was authorized by the Commission. Yes. The Commission did not authorize a CO2 project. The Commission gave them a 3-year window within which to pursue, if they elected to do so, a CO2 pilot project, with a very clear message that they're required to follow all regulatory requirements and other requirements to pursue that if they chose to do so. Which is why, in the initial instance, the division has denied both the C-101 APD for the single well that they're seeking to do a huff and puff on, and the C-103 effort to circumvent the C-108 UIC process that they filed for the pilot project for CO2. So just for your awareness, our view is that they have to follow the regulations, and I think it's the divisions as well. The division briefed it to the Commission. And so they haven't yet done so, and they are now substantially out of compliance with the division's requirements to even get any approval. So our view is that, I just want to make clear that your question, I think, was whether the Empire has pursued what the Commission has authorized, and I just want to make clear that the Commission, what they authorized was a 3-year window for them to do the work, if they choose to do so, and if they can otherwise meet the requirements of under the rules and regulations.
So what you're saying is, and if I'm wrong about how I characterized that, thank you for the correction, that the Commission did not authorize a CO2 project. It said you have a 3-year window. Go about doing it according to the division's rules and regulations.
Correct. Just sounds minor, but it's actually a big deal.
No, it helps my understanding. Ms. Hardy, would you agree with that?
Yes, and Empire will commence the project in accordance with the division's regulations within the time period established by the order.
All right. And Ms. Hardy, if you disagree with how please feel free to correct me.
Sure.
Because, this is a complex matter.
It is.
And I'm stepping in. Hopefully not stepping in, but yeah, you know what I'm trying to say. All right. Given the 3-year clock started when the stay lifted December 17, do you agree that's when the 3-year clock started?
I think that's correct.
Okay, fine. Does it make sense to press forward on 13 new revocation cases, testing the same recoverability question before Empire's own sanctioned pilot has produced results?
Yes, I think it does, because the order issued by the Commission suspended Goodnight's existing permits and imposed requirements regarding their wells that we sought to revoke, subject to us commencing the pilot project. Once we commence the pilot project, they need to shut in those wells And there is a whole, slew of requirements that apply to Goodnight. And I know that Goodnight has not filed its shut-in plan that it was required to file by the commission's order. So it hasn't complied with the order. But in any event, our position is that these wells that are the subject of these 13 applications need to be treated similarly to the wells that have been addressed by the commission, and that's part of the reason that the cases in our position should be referred to the commission. So everything can be handled consistently, and the commission heard evidence for 4 weeks on all of these wells, and so that's why it makes sense to refer them. But yes, I think it does make sense to pursue these applications now.
Correct me if I'm wrong here, because I wasn't there, but I thought the terms of the shut-in were based on the test that you were going to do.
The timeline to actually shut in the wells is subject to us commencing the pilot project, or the timelines are tied together, but the order requires them to submit a shut-in plan that shows how they will shut in the wells and what their plans are for the water, and that is not contingent on our pilot project commencing.
So I'm not sure that answers the question I asked, though, because I understand what you just said, but why does it make sense to press forward on 13 new revocation cases testing the same recoverability question before your own pilot has produced results? I mean, because if your test shows that there is no economic or some sort of recovery, why would they need to shut in their wells?
Well, the wells, since these wells have not yet been dealt with,
Yes.
I think they need to be treated the same way as Goodnight and the other operators' other wells. And that would require a determination, I think, that these wells have to be shut in when we commence. I mean, our position is they should be shut in now.
Right. I know you. I know.
And I think that, we would present evidence to show that. But delaying a determination on these applications until our pilot project commences is inconsistent with what the commission's done in the other cases. Because right now, in the other cases, the wells have to be shut in once we commence the pilot project. And there's no determination for these wells along those lines.
So your understanding, and I'll go to you in a minute, Mr. Rankin, your understanding of the commission's order is once you get an approved test pilot, that's when the wells get shut in so that you can conduct your?
They get shut in once we submit a notice of commencing the pilot project. Their paperwork requirements.
So it's not based on the results of your?
No, because
it's when you begin your actual?
Yes, because our position is that, and I think the commission found this, that the injection interferes with our ability to do the test.
I understand. I was unclear, but now I'm not unclear. Mr. Rankin?
May I share my screen?
Yeah, please.
Okay, let me get to the place where I can do that in one moment. And this, Mr. Hancock, I'm just going to say, largely is what is going to go in the briefing. And I also want to say a couple things about that is that it seems to me that a little bit of this is premature because we've got 6 cases pending at the commission.
I know you do.
That have been stayed.
Yes, I know.
And they're seeking to lift the stay on that. We briefed whether those cases should be dismissed or continue, or the stay should be continued. These are cases dealing with wells outside the EMS. Correct.
Right? Okay.
Correct. And so here I'm gonna kind of talk about this a little bit in the context of these cases at the division and the cases at the commission. Okay.
Right.
So here you'll see the 4 cases, the 4 wells that are subject to the suspension. Okay. Currently, are these 4 wells here that I've highlighted that I'm pointing to?
I see.
In section 17.
Mm-hmm.
These other wells out here were the wells that were denied by the commission.
Denied injection authority.
Correct. They're new wells that were
Okay.
proposed.
All right.
And they were not permitted.
Okay.
Other wells that were stayed by the commission are outside the unit. Okay.
I remember that.
Now, and what the division, as you recited, the division essentially found that there is no current impairment and no recoverability proven for the ROC in the unit. Okay. So what the commission's been asked now to determine is whether or not the cases only relating to Goodnight outside the unit should be lifted. And the issue there is just as you posited, why should they be lifted when they haven't yet even proven what the commission has asked them to establish within the unit? Okay. So now they're asking it, before the commission even addresses that, they're asking the division to address that earlier and before the commission addresses it. So when these cases were first referred to the commission to be heard in the first instance, it seems out of order. Okay. So at the very least, I would say let's hear what the commission does first on those 6 cases before we get all fired up to brief all this when the commission has yet to weigh in on it. That's my first thought. I just think in terms of our schedules, our effort, and so forth, it doesn't make sense to do that now. So, but further addressing your question here, and to Ms. Hardy's point, which seems to be that these wells are not in the same position as these 4 wells. Well, yeah, that makes sense because look at them. They're all over the place. Some of them are more than 1.5 miles, almost 2 miles away from any of their units. Of course, they're not in the same position as the wells that are in the unit. They shouldn't be. There's going to be different evidence, different burdens to establish for these wells outside. Okay. If they even should be heard in the first instance, the commission's precedent has been upheld previously that when you're more than 1/2 mile away, unless you can actually show injury, then they dismiss the case. So I understand your point that the commission has found that there's a potential injury based on the model for the future, potentially, but that is still contingent on whether they can show that there's an ROZ, which is this 3-year project. So it hasn't yet been established, which is why they gave them that 3 years. So my point here is that let's wait for the commission to rule in September. Let's see what they're going to do. And depending on what the commission does, then I think we have some direction as to how to proceed here in the division cases. So I think in terms of order of operations, I think the first thing would be if the commission wants all these cases to be up at the commission level right now, to be heard and considered all at once, I think that first question is, does the division director want to refer all these cases or to consider referring all these cases to the commission? And if he's willing to consider that, then I think we should have briefing on that so that the division director and the division can hear the arguments about why that's prudent or not. But as to whether or not these new cases should be heard and briefed even before the commission addresses this issue in September, I think that's totally premature. And I think we ought to wait for the commission to decide what it's going to do with these cases outside the unit boundary.
Thank you, Mr. Rankin. I have a question, Ms. Hardy, before I go on to the next. I have a group of questions, so this may take a while. Ms. Hardy, why weren't these 13 cases filed back when the other cases were filed a year or so ago?
We were prioritizing the wells that were injecting into the units directly. Really, it's a matter, I think, of magnitude of the number of applications, the number of parties. So we tried to divide them up in a manner that seemed more manageable. But all of the wells impact the units and also Empire's acreage surrounding the units. They don't just own within their units. And so I think procedurally, that's what's going on. Although at the commission, when we did file the applications involving the wells outside of the unit, we had requested that they all be heard together. And Goodnight opposed that and argued that they should not be. So the commission separated them and stayed the wells outside the unit.
So the 13, I mean, I have a map in front of me. I know it's not it's not a helpful map when it comes to where the 13 cases lie. How many of the cases are inside the unit and how many of the 13 are outside the unit?
So in our motion that we filed yesterday, and actually I could share my screen, it might be helpful because
Yeah,
I have
of
a
course,
different
please.
map that I could pull up here. And this, are you seeing my screen or not yet?
No.
Okay.
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 The blue line is within the EMSU. The red line, have any cases been heard by the commission in the AGU?
No.
I didn't think so.
Not yet.
Just within the EMSU?
Right.
Okay.
Right. And so this map is in our motion that we filed
Right.
yesterday.
I've seen it.
And so you can see there the wells, the yellow acreage is Empire's acreage.
Okay.
So it's outside of the units as well as within the units. And so if you look at the locations of the wells, the SWDs that we're seeking to revoke permits for, they all impact Empire's acreage, whether it's within the units or outside of the units.
And where is your pilot, well going to be? The one you filed the C101
Yes.
for? Just use your cursor and
That I
point.
don't. Ms. Shaheen, do you know where that is? We think it's somewhere around here.
Okay, all right, so in the middle of it, all right,
Yes.
fine.
Yes.
And so some of these are Goodnight Midstreams cases. So these are the 13 cases of the colored dots here?
Yes.
Is that what you're showing me?
Yes, and you can see the legend here.
Yes.
The red wells are Pilot. The, green wells are Parker. So these are all the wells that are subject to these applications.
Okay, I understand. I see. So they're really both within and without. Okay, I understand that. And you're saying that even the cases that are within the EMSU, because there are at least 1, 2, 3, 4, 5, 6, 7, 8. Looks like I see 8 cases that are either on the line or within the EMSU. They were not filed along with your other applications to revoke injection because?
So most of the Empire wells within the unit were so the wells on this map that you're seeing, those are not all new applications.
They're not.
No, like some of these, the Andre Dawson, the Sosa, the Rhino, the Ernie Banks, those are the subject of the applications that were heard by the commission.
Oh, they are? Okay.
Yes, yes. So this is showing, I believe, all of the wells that we've sought to revoke or are seeking now to revoke.
Oh, so I can't use this to know which of the 13 new cases?
No, we do identify them in the motion.
Okay. Okay, I just thought it might be helpful.
Yeah.
I understood that. All right.
Yeah.
This is a question I'm going to ask, but I think it should be on the record. So, Ms. Hardy, if the division hears these 13 cases and rules against you, you would de novo that to the commission?
Right.
Right. Mr. Rankin?
If we win and they lose, we won't know.
No, well, I mean, yeah, okay.
But if we
Right.
lose, yes, we would de novo it. Now, I just want to say, Mr. Hearing Officer.
Well, I don't
Yeah,
want to,
okay.
don't give me the long thing right now. Mr. Beck?
I don't know the answer to that.
Oh, you
but
don't?
I expect that any party that is not successful will appeal.
I would think so too, but I just wanted to hear it. Mr. Suazo?
I think Pilot stands in the same position. I think, the map that is on the screen from Ms. Hardy is instructive, given where Pilot's well is located. It's a marginal well. It injects, I think, an average of 15 barrels a day. So it's a pretty nominal well in the scheme of things, but nevertheless, we're being, placed in the position of this potentially being shut in, which is, I think, an extraordinary measure here.
Okay. So you would appeal, if the division found against your client, you would appeal that to the commission, right?
Yes, that's correct.
All right. Ms. Hardy, I want to understand the evidentiary basis, whether this is going to be on the same record or whether we're going to have new evidence at this, if we conduct a hearing before the division. And to clarify Mr. Rankin's point before, he was saying, well, why are we even dealing with these motions before the commission makes a decision on what's in front of it in September? What exactly is in front of the commission in September?
Empire's motion to lift the stay to proceed on the Goodnight's wells that are immediately outside of the MSU.
Yeah.
And Goodnight filed a motion to dismiss based on standing.
Oh.
And I will note that argument's already been rejected by the commission previously. So it's the same argument and the same argument that Mr. Beck is going to make, I presume, on the half-mile area of review for an SWD.
Based on the injury, in fact.
Right. And I think we've refuted that. And I think the map I just showed also refutes that because there are interests outside of the unit as well.
Okay, so that's what's in front of the commission in September is motions to dismiss. Motion to dismiss just the cases outside the EMSU, the 6 cases that are on stay, Mr. Rankin?
That's right, I think.
Yeah, correct. And to Ms. Party's point, the commission has not yet heard a motion to dismiss following the evidence in the case in the order. They have not heard that yet.
Okay.
So this is an opportunity for them to rule on the cases outside the unit subsequent to their order.
So it's your motion, or is it Mr. Beck's motion, or both of your motions?
It's our motion because while Mr. Beck's in the case and Mr. Suazo is in those cases, it's our wells, it's Goodnight's wells. So we filed a motion to dismiss those 6 cases that are still pending before the commission on the basis that for standing, essentially.
Based on injury, in fact?
Correct, based on the findings of the commission in the unit, correct.
Mr. Beck, you joined in that motion?
I think we did, as far as I recall, yeah. I think we did. I can't recall right now, but I'm pretty sure we did.
Do you know if Mr. Beck joined?
I do not.
Okay, you don't.
As I said, I'm always happy to back up Mr. Rankin. So.
All right.
If not,
Mr. Suazo, did you join in that motion?
I also don't recall, but we're certainly with Mr. Rankin in spirit and here for support today.
Yeah.
You're carrying quite a burden, Mr.
Yeah, I don't think Mr. Suazo actually technically officially joined. I believe that Rice and Permian did on the motion.
That's my recollection too.
But my point is simply that they're in the case. They're in the case. I believe at the commission level. They're both in the commission.
So based on what you said earlier, if the commission does, grant this Hail Mary of yours to dismiss these 6 cases, what does that have to do with the 13 new cases for the ones that are within the EMSU?
So there's only 2 cases in the EMSU.
Oh, there's only 2?
Yes. So again, I'll show you the map because I don't think this was. So in the EMS, the 2 cases that remain. So just procedurally, there is the N11 and the P15. Okay, one
when
is
you say remain, what do you mean by remain?
I'm sorry. That they filed applications.
The 13 new cases.
Of the 13 cases, N11 and the P15. These both were previously filed by Empire, but they dismissed them without prejudice to file them again. Okay, which is what they've done here. So they're only of all the 13 cases, there are only 2 that are in the unit, and those are the N11 and the P15.
Okay.
Forgive me for my.
So depending on the commission's decision on the injury in fact outside the EMSU, some of the Empire cases may go away based on the same argument.
True. I guess technically these two cases for the wells inside the unit are potentially, I guess you could argue, are in a different posture because they're actually in the unit. Okay.
Right.
All the others are outside the unit.
I understand.
Okay.
That's helpful.
Okay. So just to be clear, the alternative relief that we're seeking at the commission is to dismiss or to keep the stay in place pending the results of their analysis.
I see.
Okay. So it's not simply whether they will dismiss or not. It may be that they say, look, these other 6 cases outside the unit, there's no good basis to go forward with them. We think we need to wait and see at least whether there can be recoverability and whether, so that's an alternative relief. And so I think very reasonable to wait for the commission to decide on how they want to handle those 6 cases.
So right now, we just have a motion to refer on the table.
Correct.
And we don't, I mean, if parties want to file motions to dismiss, it seems it would be premature based on what you're saying, what the commission may or may not find withstanding. But the August 5th deadline for the responses to the motion refer does stand. I'm not going to tell the parties whether they want to file a motion to dismiss or not. I would probably hold that in abeyance until the commission made its ruling. I think that's reasonable, don't you, Ms. Hardy?
I do, and I do have one correction. There are 3 wells that are inside the unit, actually.
Which ones?
It's the P15 number 1, the EME SWD number 21,
okay.
and the N11 number 1.
Perfect.
Forgive me, I really did like the EME SWD 21, and I'd forgotten that it is actually inside the unit.
All right. All right. So, Ms. Hardy, evidentiary basis, because these are your cases, you have the burden of proof.
Yes.
So I'm going to ask you these questions. The ROZ existence, fracture communication, and future impairment findings in R24004 were built on core samples from 2 specific wells, EMSU 679 and RR Bell number 4, and Dr. Buckwalter's model. For each of the 13 wells here, is Empire relying on new well-specific evidence or asking to extend those EMSU 679 RR Bell findings by analogy?
I think that we would show that the geology is the same outside of the unit.
Okay.
In this area, we may provide additional evidence if there is additional evidence that's been identified, but.
Perfect. That helps. That helps me. Okay. All right. Okay. For the wells actually inside the EMSU AGU, that would be the OWL P15 number 1, the Permian lines EME number 21, and N11 number 1, Rice's Blindbury Drinkard number 18. Those are all together. For the wells actually inside, does the operator agree this directly implicates the same theory already addressed in the commission's order, or is there a distinguishable factual basis?
For the wells within the unit, I think it's the same.
The same.
And since the Blindbury Drinkard is a Rice well,
yes,
I'll just point out that is in the AGU,
yes,
not the EMSU. And so there's going to be, I expect, different evidence, different geology. I think it's a far cry to say that the same evidence presented only inside the EMSU, given the variations we saw throughout the EMSU, would apply equally to the AGU.
Would you agree, Ms. Hardy?
No, I think the evidence is going to be very similar.
Okay. All right. Well, we will see. Okay. Mr. Rankin, you didn't have anything to say about that, did you?
Well, I mean, I will just say it's 7 or 8 miles away, the Drinkard, for example, and there's, zero evidence that there's any core data, anything from the AGU.
Okay.
And I just can't imagine how any geologist is going to get up and say it's the same.
You can find an expert to say anything. All right, Ms. Hardy, for the 2 Goodnight wells never part of R24004, that would be the Penrock State E27 SWD number 2 and the Scully State SWD number 1, both outside the EMSU. Does Goodnight view, well, I guess I'm asking Mr. Rankin this question. Does Goodnight view these as meaningfully different from the 4 wells already suspended or substantially the same theory?
Yes. Which wells again were you referring to?
Sure.
Yeah.
This would be the Penrock State ETR27 SWD2 and the Scully State SWD number 1.
Yeah, substantially different.
Substantially different.
This area is dictated by structure.
Perfect.
Okay? And the reason that they chose their pilot well where they did is because it's on the very top of the structure.
Okay.
where they have the very best likelihood, and they're only targeting what we think is really Grayburg, okay, is what they're targeting, the very, very top of what potentially has any oil. So yes, very different.
Okay. And just for my information, Grayburg is above or below the San Andreas?
Grayburg is above.
I thought so. And there's communication between the two?
No, there is not.
Yeah.
But the commission found that there was?
No, the commission found that there may be communication.
Maybe. Okay.
No, there's, in fact, and I can get into it.
No, thank you. No, thank you. No, thank you. Save that for September. All right. For the in-part wells outside the EMSU AGU, what evidence connects them to the future impairment showing the commission accepted for the EMSU core wells specifically?
I think the evidence is similar in that the geology, our expert testimony would be that it's very similar and that the findings extend.
Okay. I'm sure you disagree. Obviously, yes. I know that, yes.
And
I'm just
also-
asking, I'm asking to make a determination
Yes,
on referral.
I
really.
understand.
I mean, I know you're going to brief this, but seeing as how the commission has sent these cases back to the division for the test well and to deal with this, that says something to me. Okay, legal framework, settled or still contested. The amended order in December already resolved that the commission and OCD by delegation can suspend injection to facilitate the recoverability test without proof of current impairment. Do the parties agree that legal framework governs here, or does anyone contest these 13 cases present a distinct legal question requiring the commission's resolution? I'll start with you, Ms. Hardy.
Sure. No, I think the question is the same, and I think it's resolved by the commission's order, because under the Oil and Gas Act, the obligation to protect correlative rights and prevent waste includes the residual oil zone that the commission has found we proved existed.
So the answer to the question is that the legal framework does govern.
Yes.
From your perspective. Mr. Rankin?
I'm going to ask you just to reframe the question because I'm not sure I understood exactly what you're asking.
Okay, I'm just going to read what I have here again.
Yeah.
The order, now I'm specifically speaking about the second order in December, R24004A, already resolved that the commission and OCD by delegation can suspend injection to facilitate a recoverability test without further proof of current impairment. Do the parties agree that legal framework governs here, or does anyone contend that these 13 new cases present a distinct legal question requiring the commission's resolution?
Yes, I think that the facts don't apply because these wells are outside the unit. And what they found was that injection in the unit, the legal framework that decision the commission made was largely governed by the fact that there's a unitized interval, that there's a unit agreement in place, that Empire has authority to govern operations for recovery within the unitized interval. The question here is whether or not any of these wells injecting outside the unit is a factual question, have any impact at all on their operations in the unit. It's a different set of issues, different set of legal issues that have to be addressed with these facts.
That's interesting. You said something I thought was interesting. You said that it's a factual issue of whether any of these injection wells outside the unit would impair recovery within the unit.
I think that's my understanding of their applications to revoke, okay, is not that we're impairing anything outside the unit, but that we're impairing their operations inside the unit. That's my understanding.
Okay.
So if I'm wrong, they can tell me, but that's the way I understood their allegations to be framed in their applications.
So the legal framework would not hold there?
No, it's a different question. A different factual question is whether or not the injection outside the unit is having any impact on operations in the unit.
I'll come back to you in a minute because I know you probably want to clarify. Mr. Beck?
Yeah, I think I largely agree with Mr. Rankin. I think what he's saying, and I think probably we're all on the same page with this, even Ms. Hardy, is that the division and the commission are looking at waste and protecting correlative rights. That's the legal framework that applies. We're stuck right now, I think, as the division is probably stuck with the commission's orders, right? The commission has made its findings, has made legal determinations. I think what Mr. Rankin is saying is that some of those findings may not be preclusive in a division hearing for applications to revoke wells injecting outside of the unit.
And 4 of the 13 cases are within the unit.
That's right. Okay. Yes, so I think for the other 9, we've got the legal framework provided by the statutes and the commission. The question is how the unitization impacts those wells that are not within the unit. So I think that, so your question was, do the same legal principles apply? Yes, they do. But some of those legal principles, as Mr. Rankin points out, were premised on the Unitization Act and the unitized interval. And so that will be a difference factually and potentially legally for the 9 out of the 13 that are not within the unit.
Okay, Mr. Suazo?
I agree with, everything that Mr. Rankin and Mr. Beck just said. I mean, I wish our well, Pilot's Well, Owl's Well, the P15 was a little bit further to the southeast than it is on that turquoise line, but here we are. Sure. Again, I think just to reiterate, even if we develop the facts, having this well cease injection is an extreme remedy given that it's marginal. And so we want the opportunity to present that. And I think there's other, far more pressing, far more impactful developments surrounding, this area within the EMSU. So Pilot's a little bit differently situated, I think, except by geography.
I see. Ms. Hardy? Back to if you'll answer that first. The premise of that Mr. Rankin brought up first. Will you answer that first?
Yes, my understanding, of his point. The legal framework, I think, is the same. Okay. Because the commission is obligated in the division to prevent waste to protect correlative rights, which includes the residual oil zone, within and outside of the unit. I think. So there are 2 factors, right, on the wells outside of the unit. One is whether they're impairing correlative rights within the units, whether they're reaching, whether injection fluid is reaching the units and impairing correlative rights. And then I think there's a second inquiry that involves whether they're impairing correlative rights outside of the unit. And I don't think the commission's order is specific to unitization, and I don't think the legal framework is. I think the obligation applies whether you're talking about correlative rights inside of a unit or outside of a unit.
Okay. All right. Okay. Ms. Hardy, your motion to refer talked about the public importance factor.
Right.
Does any party dispute Empire's characterization that federal, state, and royalty owner interests make this a matter of substantial public importance as opposed to a private correlative rights dispute between operators? I'll start. Well, I mean, it was your argument, so I'm going to go to Mr. Rankin first.
Well, I mean, I think that this whole area is of great public importance. This whole debate is of great public importance. Upwards of 50% of New Mexico's produced water is being exported to Texas because the state has not been approving saltwater disposal wells anywhere. I mean, there's been 1 approved this year, maybe 2, fewer than 5 in the last, fewer than 10 in the last 2 years approved. There is a crushing need for the state to step up and manage its produced water. And these operators have identified a gold mine for disposal of produced water because the San Andres is extensive. It is, has superior capacity. After 8 years of injection of over 300 million barrels, the entire reservoir has increased in pressure marginally, okay? So what we have here is of great public importance. And the injection that's being threatened here is serving a substantial amount of existing actual operations in the Delaware Basin. And so, yes, this is of great public importance, but not for the reasons they're saying. Because there's been no proven ability to recover any of this ROZ. The allegations that it's been proven, we dispute strenuously. The core that the commission relies on doesn't even go down into the disposal zone. Okay, it is it's almost 100 feet above, at least. So there's actually no physical proof of oil in the disposal zone. Okay, so yes, this is a problem, and we need to address it. And it's unfortunate that it got to this point. But our view is that yes, this issue, all these wells, and the entire San Andres as a target for disposal is of incredible public importance, and it's not getting the attention it deserves.
I can understand that. Thank you. Mr. Beck, Mr. Suazo, you basically agree with Mr. Goodnight? With Mr. Goodnight?
That's what we call him too. So.
I refer to him as Captain Goodnight, actually. Wearing a cape.
Oh, brother. Mr. Beck, that means yes, you agree?
No, I'm not sure that I do. Actually, we don't depart ways very often. I'm not sure that, I certainly think that these are issues of public importance. I've heard before that there's no such thing as a big or a small case to everyone involved. It's the biggest case that they're in. And I think that's probably true here. I don't know the definition for purposes of 1915-420, what is a matter of substantial public importance, and I don't know if this qualifies. So I can't answer that question.
Okay, Mr. Suazo?
I will remain aligned with Mr. Rankin on this one. I do think that there is significant public importance, and there's also, specific importance to pilot. I mean, yes, there are produced water issues, but, in this case, our well is so far away from the pilot project and, injects such a marginal amount of water, which is still limited in nature and is a valuable asset to pilot, or else they wouldn't be in this thing. There's importance to the public and definitely to pilot individually. And it seems like what Empire is asking with respect to many of these wells is a fairly blunt instrument in a pretty nuanced situation.
Okay. Can I have one comment to my, it's a shorter one.
What are you making a comment to?
To the question of public importance.
Okay.
I think because it is of great public importance, I think that, and because the commission has referred a lot of this management of both the suspension of injection and the implementation of any potential pilot project, I think speaks to the commission's intent and desire to have the division reassess these issues. And for purposes of articulating what the commission needs to focus on, I think it would be important for the division to have these cases heard and have the evidence. There's going to be new evidence, and there's going to be a different set of factors that are evaluated with these cases outside the unit. I think it's of great importance that these issues be better crystallized at the division level, so that when they do go to the commission is better equipped and the parties are better equipped to focus what the actual issues are. And so I would urge, to the extent that the division directors would consider referring these to the commission, would be to first have these heard out at the division level for that reason.
Okay. Ms. Hardy, when do you anticipate, if we clear away the motion to refer and we deal with the motions to dismiss if they are, if there's any basis for them, when do you anticipate wanting to hear these cases?
I think probably as soon as possible, but I do think it makes sense to refer them to the commission so they can treat them consistently. But if they were going to be heard by the division, I would think within a couple of months.
So we have to wait for the commission to deal with in September. So that means, October, November, something like that. Would you like to consult your client?
Yes.
And discuss witness availability?
Yes.
You have the burden of proof here and persuasion. I think I'll leave it here. So Mr. Rankin, Mr. Beck, Mr. Suazo, please discuss dates in October, November for, if we don't refer these to the commission, to have a hearing here at the division level in person. Witnesses don't have to be in person, but yeah, I mean, I haven't decided how I want to proceed I need to hear the responses to the motion to refer and then see about dismissal, but that's what I'm thinking right now before I'm more well informed. Ms. Hardy, am I missing anything?
I don't believe so.
Okay.
Thank you.
All right. So it sounds to me like there's not going to be a lot of new evidence. There's going to be evidence that is given to the division or the commission, asking us to extend that evidence to areas both within the EMSU and outside the EMSU.
That's my understanding, but I'm not a geologist,
Right.
so there may be additional evidence as well.
Okay.
But that's my understanding.
I mean, you had 4 weeks of evidence in front of the commission. I would think that every stone was overturned. But you never know. You might find another expert. Mr. Rankin?
Yeah, I mean, no, I think we'll confer with among counsel and with our clients. I think it's worthwhile having a discussion among the parties for an orderly hearing to figure out how, given that that these wells extend across an area of, I'm going to say, 50 square miles. How on earth we're going to do that in the context of a single hearing, where each well will need to have, they need to make the burden for each well, and so it'll be interesting to see how it all plays out. Yeah.
I think depending on how the motion practice goes, we'll definitely have another status conference. At that status conference, I'm going to ask you, Ms. Hardy, what are the issues going to hearing? And I'm hoping that in that time you will confer with the other parties and try to whittle down the issues so we don't have a free-for-all here.
Understood.
Because I've seen how other hearings go, and that's not going to go on here. We're going to have a very discrete list of issues. Witnesses will have a time limit to present their cases. We're going to do this in a very orderly fashion if we do it here at the division level. Mr. Suazo, anything further?
No, Mr. Examiner, I think we've covered everything in that path with respect to narrowing the issues. Sounds good to pilot.
Of course. Mr. Beck?
Yes, Mr. Hearing Examiner. So I wanted to revisit the issue of the scheduling order.
Sure.
I think that Mr. Rankin makes a very good point, which is that we shouldn't let the tail wag the dog. What's going to happen in this case is going to be determined in September by the commission. And so it makes infinite sense to me to wait on the commission to see what they do with the motion to stay and the motions to dismiss, and that we reconvene after that time. Now, I don't think that it necessarily needs to hold up the motion to refer. I think that I don't know if the division and commission are interested in that, but if they are, again, I think that we can just, for now, set response deadlines on the motion to refer and stay everything. I think that October and November is unrealistic for a hearing. The EMSU took 4 weeks over the course of, I think, 3 months. And from what I can tell, and I don't know the tip of the iceberg compared to Mr. Rankin, but it seems to me that there is a lot more research and evidence about the geology and hydrocarbons in the EMSU than there is in the AGU. And so when we're going to move to the AGU, I would expect that a hearing on the AGU would take that amount of time or more or less, depending on what the evidence is. And then when you're moving outside of that to a non-unitized unit, I would expect that there's less known. And so if we're going to include all of this in one, it would surprise me if we could get that done in 6 weeks. And it would surprise me if we would be ready for that by next July to present all of the evidence they would need to present. I'm putting those issues out there. As you said, you instructed us all to talk about this, and I think we'll do that. I'm just not sure we're going to be able to all agree on what that looks like. I just want everyone to go into this with eyes wide open, because as I differentiated between the legal issues and the factual issues, this is all dependent on the facts. And I have, from what I saw, and I probably know the least amount of geology in anyone in this room, but I was shocked to see the differences just within the EMSU. And when we're talking about a unit 7 miles away with less research, it seems like a giant intellectual leap to say that anything in the EMSU is applicable to the AGU and vice versa. And then when you move outside of that, it seems a very hard cry. So, you know, if they're stayed and it turns out they can't produce the ROZ, it seems like an immense amount of resources that go to waste if we go through all this rigmarole in the next 2.2 years and it turns out there's nothing there. Getting back to the scheduling order, I think August 10th is a fine deadline for a response, given that we're going to wait till September. I'll note that all of the parties in here have a district court hearing next Wednesday, which I anticipate will be all day. I think that's true. So although a 2-week deadline would usually be okay, given that we've got time to hear from the commission until September, and given that we're all going to be working for that hearing next Wednesday, and all-day hearing in both these cases in the district court, I think that August 10th is not prejudicing anyone to have our responses to the motion to refer filed on that day.
Thank you, Mr. Beck. Ms. Hardy, do you have anything to say about August 10th?
No, I think I don't object to that, but I do think it would be helpful to have a decision on the motion to refer before the commission hears the other issues in September, because if the cases are referred, of course, that impacts what they're probably going to hear.
Okay, that seems fair.
Can I ask for a point of clarification on what the motion to refer actually is requesting? I guess, is it requesting that the division director make a decision about whether the cases should be heard by the commission, or is it asking whether the hearing officer should ask the division director whether cases should be heard by the commission?
Ms. Hardy?
Well, I think it's under the rule, the motion is made to the division, and the division director would determine whether to make the referral, but I imagine that yourself would be involved in that decision with the director.
Okay. Seems like a fair characterization. All right. Did I not call any cases? No, 24491. We're back to your case. Yeah. This is an extension case.
Correct.
It's a case in which you received an order. What is the status of that order now? I know it's told because of your application. It's years old, right?
Correct. So we filed this case application to extend the authority to commence injection because Empire had challenged the injection authority of wells in the unit and outside the unit. So at the time, for a number of reasons that are now of record because we filed some testimony already in it, Goodnight determined to not drill the well and then to seek an extension to do so. And we asked for a 1-year extension from issuance of the order. And that 1-year extension now itself has passed. So the status of this is that all this has been told by the fact that we filed the application and have requested the extension. Having lifted the stay, we're now seeking and have requested, and I think the division has directed us to determine a date for a hearing on the good cause for why the extension should be granted. So to that point, I guess I can tell you that our witnesses are available in September 15th, which I understand is the only date in September for a special hearing date. So our witnesses can be available that date. And then also in October, if that is necessary. I think I conferred with Ms. Hardy, and I think September 15th worked. I can't recall, but maybe it was later September worked. Forgive me for suggesting, but if September 15th doesn't work for them, I think then we'll have to look for October, unfortunately.
Okay. And I think we also we also put another case in recess for parties to discuss with their clients September 1st or September 9th.
Correct. And
so I'll get to it in just a minute. I don't want to confuse things.
Yeah.
We're still talking about 24491. So Ms. Hardy, obviously you oppose this extension, but it is a good cause based extension. Now, whether the division grants the extension or not, I'm sure you'll appeal that to the commission based on what's going on in the rest of the cases. So
Right.
You have avenues open to you. Do you have it's Mr. Rankin's case, so I tend to give preference, but do you have something to say about the date?
I think that the September date would work.
Okay.
I haven't conferred with my client about October.
Okay.
I think both parties had asked at one point to refer this case to the commission as well.
Right.
So we didn't revisit that in our motion.
Right.
But I do think that it's tied up with the other cases in that whether the extension, how you can grant an extension on an application on a permit where showing should
Sure.
show should be revoked.
Yeah, no,
So but
do you have a separate case asking someone to revoke the injection of this well that they're asking an extension for?
yes, we do.
You do? You do, okay, all
And
right.
it's at the commission.
And that's a stayed case with the commission right now?
It is. Yes.
Okay. Well, I understand. Mr. Rankin, anything?
no, I agree with Ms. Hardy that case is part of the case to revoke, is part of the commission cases that are stayed that are going to be taken up at the September 17th commission docket.
Okay, I understand.
So I guess on that note, well, I would argue it makes sense to postpone any hearing setting on this case until we know what the commission's going to do on the stay on the other companion
Because
case.
if they lift the stay on the other, however, if for some reason we don't find good cause, then the case goes away,
True.
right?
Yes.
So they're independent of each other. Just because the commission lifts the stay doesn't necessarily mean that how the good cause is going to be handled. I still think we should hear it at the division level and do our job here and let you do what you do at the commission level on that case that stayed. So on the table is September 15th right now. Are you prepared for September 15th?
I think I'd prefer the October dates, but I need to confer with my client regarding availability on
Okay.
those dates.
Do you guys want to discuss
Yes. I think so.
Well, I mean,
Not that you can agree on anything, but maybe.
we are ready to go September 15th. Obviously, this case has been pending for a long time.
Years, yeah.
And it's a simple case about good cause. And obviously, the good cause is simply because Empire is seeking to revoke all these cases, and we just, stayed it, didn't drill for that reason. So, I think it's fairly simple. We'd like to go forward with it on September 15th. I'm willing to discuss with Ms. Hardy, but I think, we'd like to get that September 15th on the docket so that we can prepare our witnesses and get ready to go.
Ms. Hardy, how much time do you need to discuss with Mr. Rankin? Because what we'll do is we'll just hold off on the pre-hearing order until you guys have discussed the date. And could you let us know by tomorrow
Yes.
afternoon?
Yes.
Okay. Then we'll just hold off on this. We're looking at September 15 for a good cause hearing only, but we're going to wait until tomorrow to issue that order, and possibly that'll go to October, possibly not. Would you help me? So this must be a well that's outside the EMSU, isn't it?
Yes, it is.
It is.
It's a little more than a mile outside.
Okay. All right, fine. I just didn't remember that. Now, let's go back to what was the case that we were waiting for September 1 or 9?
It was your favorite case.
I have many favorites.
Forgive me for presuming. It was
Yeah.
case, it's number 16 on the docket
Got it.
worksheet.
Got it. 16. So
And
this
Mr. Suazo is involved.
Oh, yes, Spur Energy. Yes, Mr. Suazo wants it sooner, and you would like it a little later. And we were talking about September 1 and 9. Mrs. Suazo, it's your case, September 1 or September 9?
September 1, it needs to be.
That's right,
Okay.
you said that earlier. Are you okay with that, Mr. Rankin?
Let me just double check again, because I didn't, before Mr. Suazo said that I offered him 1st or 9th, so he told me the 9th worked for him, so, 1 second.
I understand why it doesn't work for Mr. Suazo.
1 second, I can't type. I can't. Apologies.
Ms. Hardy, while he's typing, did we recall 26151, the Permian Resource case? That's number 8 on the docket?
Not yet. We need to do that.
We need to do that too.
Yes.
Mr. Rankin, why don't you take a break and do your thing? Let me recall case 26151. Ms. Hardy, where were we in this case?
So on that one, I was conferring with my client regarding the notice to
Yes,
Ms.
yes.
Shaheen's client.
Yes.
And it looks like notice was sent in May, but it was returned to us.
Okay.
And so I'm
Who'd
not
you send it
sure. To FE Permian.
FE Permian.
So I'm not sure why it was returned, but regardless, FE Permian had received the well proposals in March, and I have that tracking number, so I know
Okay.
that they received those.
All right.
And then Ms. Shaheen had entered an appearance in the case on June 2nd.
Okay.
So they've known about
Okay.
the case for a month and a half at least at this point.
Ms. Shaheen?
Yes, I agree with that, although there was an interesting fact, and that is Ms. McLean had given us a tracking number, and it was for FE Permian, and the tracking number that she gave us may be incorrect because now that USPS says it was delivered to someone in Santa Fe, and the address is not in Santa Fe. So somehow that got lost in the mail. But what I also can tell you, FE Permian does have the interest. Flat Creek will be the contract operator in the competing proposal, and FE Permian did not receive notice. I don't know whether they received the well proposal. I'm assuming they did.
If Ms. Hardy represents that they did, then I trust Ms. Hardy. Okay, so we're still talking about how we should proceed on your case, Ms. Hardy. It's your case. How do you want to proceed?
Yes, we would like to set a contested hearing on August 18th.
Okay. We'll issue the pre-hearing order for August 18, Ms. Shaheen, and if there's a good reason to continue it, and there may be, then you'll file some sort of a motion explaining why I should delay it. Okay?
Okay, but I thought it was August 15th.
Maybe it is. I don't know.
But 18th is better. It's 3 days later.
Freya, is it August 15 or 18?
It's 18.
Oh,
It was September 15.
August
The
18th.
15th's a Saturday, so.
No, we can't do it then, yeah. All
The
right.
18th is, that makes the 18th a Tuesday, huh?
Yes.
Okay, so and I did write down August 18. I don't know where I got that from, but anyway. So we'll issue a pre-hearing order for August 18. If for some reason, Machine, you have a great reason why we can't do that, you let us know.
Well, do you think that submitting our well proposals and being on the September, actually, it would be the first October docket, is that going to be a?
I mean, have you already sent out your well proposals?
No.
Well, I mean,
To send out our whether we send out our well proposals now or August, I think it's the 8th. The soonest docket we can get on
I
is
understand
October.
that. Based on what Ms. Hardy said, the idea that the well proposals were sent out in March, and the case was filed in May, et cetera, you'll have to give me a good reason why your client has delayed sending out its own competing applications.
We will do that.
All right, fantastic. Mr. Rankin.
I was able to talk to the landman for Spur, but he couldn't get the availability of the geologist or the engineer yet. So, I mean, I can tell you, they're at lunch and they're trying to track him down, but I can get you an answer today, early afternoon.
We'll move forward with September 1st. If you need to file a motion with an affidavit on why we can't hear it September 5th, we can also start on September 1st. We can also start on September 1st. Freya, what day of the week is September 1st?
It's Tuesday.
Tuesday.
A Tuesday. I mean, maybe we start on the 1st and continue on the 2nd, depending on availability. I don't know. But you would be going first, so your witness availability is critical. Okay?
It is critical, yeah, as it is our application. So I will endeavor to find out their availability. I will just say, I know the division wants to get it done. I know there's some issues to get resolved, and we want them resolved quickly as well. If the 1st doesn't work and the 9th doesn't work, 15th is only two short weeks away. So I'm hopeful that, we'll be able to get it done quickly, and I'll advise the division on our witness availability.
Okay. By later today?
Yes.
Okay. Would you also confer with Mr. Suazo, depending on what you find, so that when you give me something, it's a final that works for both of you?
I will.
All right, perfect. Mr. Suazo, anything else?
No, that sounds good.
All right, very good. Thank you, everyone. We're off the record.
Mr. Hearing Examiner,
Oh, yeah.
did you want to call the cases on the set for contested hearing next week?
We're back on the record. Can you call the cases, Freya, because I don't know the case numbers well enough?
I believe they are case numbers 25996, 26062 through 65, 26129, 26130.
And the applicants' names are?
Avant and Cotera.
Avant and Cotera. Entry of appearance, please.
Good morning again. Caitlin Luck appearing for Avant in all of these cases.
Thank you. Mr. Holliday?
Good morning, Mr. Examiner. Ben Holliday appearing on behalf of Cotera Energy Operating.
All right. Mr. Holliday, I received, Ms. Luck, I received your motion yesterday.
Yes, Mr. Hearing Examiner, I believe that we both filed motions. They were agreed motions, and they should be the exact same in all of the cases that are pending. We did have a contested hearing date scheduled for July 28th, but the parties have reached an agreement. And so for that reason, we have requested to continue it while the parties paper up their agreement, and then the cases can proceed by affidavit following that.
I would like to explore that a little bit. When you say that they've reached an agreement, can you tell me what the agreement is?
I can maybe defer to Mr. Holliday.
Okay.
He could provide a little bit more context and information.
Mr. Holliday?
Sure. The agreement in principle right now is for Cotera and Avant to trade out. So Avant would trade their acreage within the proposed Ball State units, and in exchange, Cotera will provide acreage in another section of the basin.
Okay. And so if this trade out, first of all, how long do you think it will take? Well, first of all, you said you have an agreement in principle. Is that right?
Yes, sir.
All right. How long will it take to solidify that agreement in principle?
I think it's reasonable that they could do it before the August status conference. So that's the date we requested, and I understand completely why you wanted to talk about this today. But there's a lot of acreage involved, but the parties know what they want. I think we could give them to the August status conference date and then reset things for the September hearing by affidavit docket.
What cases would move forward if this agreement is solidified?
My understanding, and Mr. Luck, please correct me if I'm wrong, because Avant is trading out of its acreage in the proposed Ball State units, it would be dismissing its cases. And then they would refile for acreage in another part of the basin when they're ready. Coterra would move forward with their applications, four applications to proceed by affidavit.
I see. Ms. Luck, is that how you see it?
Yes, Mr. Hearing Examiner. And so that's why we wanted to present these motions for continuance to the division as soon as possible before the July 28th hearing, because the agreement would be that basically one set of applications is dismissed, the other set of applications is basically consented to, but we're not in a position to put that on paper quite yet, but I do think that that's what's going to happen between the parties. Thank you.
All right. In the future, and I realize that this deal was made last minute, so I'm not annoyed that the technical examiner has already reviewed all of the data for these contested cases. It's a lot of wasted time for Mr. Fordyce, but that's the name of the game, I guess. However, at the very basic level, when parties submit an unopposed motion or a joint motion, they provide a draft order with it.
May we submit a draft order? Okay.
Yes.
I will do so, or I'll first have to run it by Mr. Holliday, but then I'll submit it after this hearing. Thank you.
Okay. And the cases, all the cases, Coterra and Avant, will be continued by the applicants to the August 20th status conference docket. That will be a final setting. If the parties have not resolved their differences, then we're going to set a contested hearing in September. Or if the parties are not, I think the parties are ready to move forward. They filed pre-hearing statements and exhibits. Is that right, Mr. Holliday?
Yes, sir. If for whatever unknown reason this breaks down, then I would presume we would just move forward with the exhibits filed as they are.
Right. And Ms. Luck, a September contested hearing, if this agreement is not finalized, is acceptable to you?
Yes, sir.
All right. Okay. So we're at the end of the hearing bureau timeframe for these cases. Either resolve them, and we'll hear the Coterra cases by affidavit in September, or we'll have a contested hearing in September. Anything further?
Nothing further. I just, on the record, want to apologize for the lateness of it, but we did get the stand down order yesterday and tried to reach out to you guys as soon as we could and file this motion as soon as possible.
Just in the future, file a proposed order with it so I can sign something or redraft it to my own liking. Anything else, Ms. Luck?
No, thank you for your time. I appreciate the division's time.
All right, so verbally, I'm vacating the contested hearing next Tuesday and ordering the parties to continue all of their cases to the August status conference docket for a final status conference. Thank you.
Thank you.
We're off the record.